Welcome, I am the Loud Little Ducky. We are going to go over the charges that Judge Matta sent over to the District Attorney's Office and for criminal prosecution. And that has to do with evidence tampering and perjury. So, Owens could be charged criminally for behavior on a civil case. Let's jump in. One of the things that Judge Matta cited in her ruling was Arizona Rule 13-2702, perjury classification. A person commits perjury by making either, number one, a false sworn statement in regard to a material issue believing it to be false. Let's see, has Owens done that? Yep. With lies when she said she saw a doctor and she didn't see a doctor. Not just a little minor perjury. The judge found it enough to send it over to criminal courts for them to take a look. Number two, a false unsworn declaration, certificate, verification, or statement in regard to a material issue that the person subscribes as true under penalty of perjury, believing it to be false. Well, we have many signed affidavits under the penalty of perjury, as well as her being sworn in during court hearings and making false statements. Then it says B, perjury is a class 4 felony. So let's take a look at what the punishments for those might be, according to the Arizona rules. So the crime/sentence for perjury: if someone is convicted of perjury, they are guilty of a class 4 felony, which is punishable by a minimum sentence of 1 year and a maximum sentence of 3.75 years. False swearing, class 6 felony, punishable by a minimum sentence of 1 year and a maximum sentence of 2 years. Those are two different statutes, but yeah, it's not good. I'm not seeing like a fine, I'm seeing jail time, because it wastes resources, it wastes money, and you do not have the right to go in court and just make up a bunch of lies because your life isn't going the way you want it to go. Now, the second one that Judge Matta cites in her ruling is 13-2809, tampering with physical evidence classification. A person commits tampering with physical evidence if, with intent that it to be used, introduced, rejected, or unavailable in an official proceeding which is then pending or which such person knows is about to be instituted. Such person, 1, destroys, mutilates, altering things, altering documents, conceals, or removes physical evidence with the intent to impair its verity or availability, which this could be her not handing over the Los Angeles stuff. She purposely concealed evidence, physical evidence that would have been pertinent to the case. I might be reading that wrong, but we have altered and concealed things. Now, do we think there's actually a concealment of things? No, because we don't think there's actually documentations that show she actually went to a Planned Parenthood. 2, knowingly makes, produce, or offers any false physical evidence. Well, we've got that. Or 3, prevents the production of physical evidence by an act of force, intimidation, or deception against any person. Yeah, she prevented the production of physical evidence by deception against the court and against Clayton. B, inadmissibility of the evidence in question is not a defense. Whether it is admissible or not admissible, you have to turn it over. The court can determine, once the evidence is seen, whether this should be allowed or this should not be allowed. C. Tampering with physical evidence is a Class 6 felony. Let's see what the sentencing and punishment is for this in Arizona. What is the penalty type for tampering with evidence in Arizona? In Arizona, tampering with evidence is a Class 6 felony. While this is the least serious felony under Arizona law, it still carries a maximum prison sentence of 1.5 years for first-time offenders, and then up to 4.5 years for repeat offenders. So she would probably be looking at 1.5 years, because technically, even though we know she has repeatedly done this, she has not been repeatedly charged. She has no criminal history as far as in Arizona, in their system of arrests and things like that. She would be considered a first-time offender. So hers would be a maximum of 1.5 years, most likely. Arizona law also allows the judge to impose a fine of up to $150,000 for felony convictions. ARS 13801. So those are the penalties and the laws on the things that Judge Matta sent over for the criminal courts to look at and possibly prosecute her on. And it's a lot for a judge to be like, nope, I'm sending this over. Because some will be like, well, if they want to do something, they can do it, or if somebody else wants to press charges. But the judge was like, nope, I'm sending it to him. I am backing this up. I'm putting my name on the line that this needs to be looked at for criminal prosecution. So it's a big deal. Let me know what you think in the comments. Hit like, subscribe, and I will see you in the next one.